In high-conflict estate litigation, it often comes down to one central question: who does the judge believe? I am Michael Hackard of Hackard Law. For 50 years, I have represented beneficiaries and heirs in trust and estate disputes across California, from the Central Valley's agricultural communities to major metropolitan courts throughout the state. In probate court, credibility can determine everything. You may believe you are right, you may feel morally justified, but in the end, what matters is whether the judge finds your version of events believable. Estate litigation is unique. The most important witness, the person whose intentions matter most, is gone. The trust creator cannot testify. The will maker cannot explain what they meant. What remains are competing narratives. One sibling says, "Mom wanted everything divided equally." Another says, "Mom changed her mind and intended to favor the caregiver." One child insists Dad was mentally sharp. Another says he was confused and vulnerable. The probate judge must decide which account reflects the truth. That decision hinges on credibility. Credibility carries special weight in probate court for several reasons. First, the decedent cannot clarify anything. Judges must reconstruct intent based on testimony and documents. Witnesses are not just helpful, they are often the only source of critical information about conversations, mental state, and influence. Second, documents rarely tell the whole story. A trust amendment may appear valid on its face, but it does not reveal who was in the room, what pressure was applied, or whether misinformation shaped the decision. Judges must look beyond the paper to the human reality behind it. Third, family dynamics complicate everything. Decades of sibling rivalry, loyalty, resentment, and perceived favoritism enter the courtroom. Judges understand that witnesses may be biased or emotionally driven. Sorting truth from grievance requires careful evaluation. So how do judges assess credibility? Consistency is often the most important factor. Did the witness tell the same story at a family meeting, in a deposition, and at trial? Minor memory lapses are normal, but major shifts in narrative, especially those that conveniently support a financial interest, raise red flags. Corroboration is critical. Can the testimony be verified? Do emails, medical records, calendar entries, or neutral witnesses support the account? When multiple independent sources align, judges are more likely to believe that version. Demeanor also matters. Judges observe how witnesses respond under pressure. Do they answer directly or evade? Do they become defensive or hostile? Credible witnesses tend to remain calm, acknowledge uncertainty, and concede points that do not favor them. Overly rehearsed answers or explosive reactions can damage a case. Self-interest and bias are always considered. A witness who stands to gain millions, if believed, faces understandable skepticism. That does not mean they cannot prevail, but testimony against interest, statements that hurt one's own position, often carries special weight because it suggests honesty. Plausibility matters as well. Does the story make sense in light of human behavior and surrounding facts? Judges are experienced in recognizing narratives that require too many coincidences or implausible assumptions. Specificity is another factor. Credible witnesses provide concrete examples rather than sweeping generalizations. Yet suspiciously perfect recall of decade-old conversations may appear manufactured. Authentic memory often includes some uncertainty. Documentary evidence can dramatically affect credibility. Contemporaneous emails, letters, and financial records created before litigation are often more persuasive than live testimony. When a witness's sworn statement conflicts with their own prior email, judges typically believe the email. Medical records are especially powerful in capacity cases. If a child claims a parent was mentally sharp, but physician notes document dementia and confusion during the same period, credibility collapses quickly. Financial records also reveal patterns. Claims of selfless caregiving may be undermined by evidence of unauthorized withdrawals or inflated payments. Let me share a composite example from a Central Valley case involving a multi-million-dollar farming operation. A father amended his trust late in life to favor one son who worked the land. The other children challenged the amendments, alleging lack of capacity and undue influence. At trial, the favored son testified that he had no involvement in drafting the amendments. Emails proved otherwise. He described his father as fully competent. Medical records documented moderate dementia. He insisted his father had always intended unequal treatment. A prior letter expressed a clear desire for equal distribution. The judge observed inconsistencies, evasive answers, and documentary contradictions. In contrast, the challenging siblings presented consistent testimony, corroborated by neutral witnesses and medical professionals. The court invalidated the amendments. The lesson is clear. Credibility is built through consistency, corroboration, and candor. It is destroyed by contradiction and exaggeration. If you are facing estate litigation, preparation is essential. Review your prior statements, understand the documents, be truthful with your attorney, even about facts that hurt your position. Surprises at trial are rarely survivable. Work with counsel to gather corroborating evidence early. Identify neutral witnesses. Prepare for cross-examination, not as a battle to win, but as a test to endure with your credibility intact. Sometimes an honest evaluation reveals that credibility factors favor the other side. In those situations, settlement may serve you better than trial. A realistic assessment is not weakness. It is strategic wisdom. At Hackard Law, we've spent 5 decades preparing cases for probate courts across California. We understand how judges evaluate testimony. We know how to build credibility and how to challenge it. If you are involved in a contested trust or estate matter, do not assume that being right is enough. In probate court, you must also be believed. Call Hackard Law for a consultation. Let us evaluate your case and help you understand how credibility will shape the outcome. Because in high conflict estate litigation, credibility often determines everything. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.